Hello and welcome to the Rogers Brief for April 6th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. I should add, I guess, if you like this content and you think others may, it helps if you like the videos and that you share them on social media or other platforms that can amplify the message and get more viewers and such. So if you're enjoying this, please do subscribe to the channel and share the videos if you feel so inclined. So normally what I do in these videos, as regular listeners and watchers would know, is I cover stories that are in the news over the past week that have either a legal angle that is prominent or else perhaps underappreciated. And I'm based in Nova Scotia, so often I'll focus on cases that are arising out of Nova Scotia and in our court system here. But this week, actually, I'm going to be covering some bigger stories that have more of a national and international flavor in certainly one case. So what I'm going to cover, I'm going to actually start off with the Nova Scotia case, though. It's a COVID-19 case in a sense because it involves a small claims court case that got my attention. And it was a $25,000 claim. Actually, it was a $28,000, but the limit in small claims is $25,000 in Nova Scotia about the price of lumber. What happens if you're having a house built and the price of lumber escalates dramatically as it did during the COVID pandemic? Whose responsibility is the price increase? All right, so we're going to talk about that. There was a case that came out this week on that issue. Talk about the Nova Scotia Court of Appeal. They've issued an annual report with a couple of interesting tidbits in there. But then I'm going to get to the big stories, and those are the indictment of former President Donald Trump in the United States, some of the legalities associated with that, something, past the headlines, but digging into it a little bit, and just some thoughts comparing the legal system and the atmosphere, I guess, in a sense, to what it would be like in Canada if a situation like this arose. All right, so the Trump indictment, the Mass Casualty Commission report, of course, I covered last week as the full episode dedicated to the Mass Casualty Commission report. It's 3,000 pages, and I haven't read the whole thing yet, but I was digging into different parts of it this week, and there's some strong language in the report, and I want to get to that as well. Dealing with the RCMP, dealing with the lead law firm that was representing most of the participants. That was Patterson Law out of Truro and Halifax. And then questions of political interference, and not the political interference most people following the inquiry would be familiar with, that being the allegations that the federal government was pressuring then RCMP Commissioner Brenda Lucki. But no, this is political interference at the very beginning of the proceedings, alleged political interference. Well, that's what the commission calls it in the report from Premier Tim Houston. So I'll talk about that a little bit as well in my continuing coverage. I'll probably spend the next few weeks looking at different parts of the Mass Casualty Commission report because there's lots there to digest. And then finally, I'm going to talk about this case that's in federal court, following up on the inquiry into the use of the Emergencies Act in the truckers' convoy, the Freedom Convoy, protest, occupation, whatever you want to call it, in Ottawa, in Coutts, Alberta, and in Windsor, Ontario. Among other locations, those are the most prominent ones, certainly, well, Ottawa being the most of them all. And so there's a case ongoing now following the inquiry. The Canadian Civil Liberties Association has brought a case to the federal court saying that the government was not justified in invoking the Emergencies Act when they did so back in February of last year. So, talk about all those things, actually, and then but I'm going to start with the case here in Nova Scotia. And this was, the name of the case is Faulkner versus Nature Ridge Homes. And Daryl Pink, former head of the Bar Society here in Nova Scotia, now a small claims court adjudicator. Both sides had lawyers in this one. This John Eddy, who's, I looked him up, he's now a Crown prosecutor. He must have been a private lawyer at the time. And Jeremy Ryant, who's with McGinnis Cooper for the defendants. And the issue was this. They the Faulkners had contracted for Nature Ridge to build them a home. And this was just prior to the pandemic. They had signed a contract. It was a long, detailed, but standard. That's a key point. Standard contract. But then the pandemic comes along. The price of lumber is going skyrocketing, and so then there's a problem. Nature Ridge doesn't want to eat the cost, and the Faulkners don't want to pay the extra because it's not contemplated in the original contract. So what do? Well, there was lots of arguing back and forth about whether it was indeed included, because there was a clause in the contract that talked about regular overages and unexpected things that come along. Well, yes, that happens in construction contracts, but this was something dramatically different. And so what happened is, through discussions, the Nature Ridge had the Faulkners sign and they agreed to sign this Schedule E to the contract, which indicated an increase in the price of lumber to the tune of $28,000. All right. So what the Faulkners claimed was that they signed that under duress, because what happened was the Nature Ridge was going to say, well, if you don't agree to this, and this was late in the construction, if you don't agree to this, then we'll give you back your deposit and you're not getting the house. And they needed a house. They didn't have anywhere else to go, and the price of real estate was going crazy as well, so they didn't have any other options. So they signed this agreement to pay the $28,000, signed it in their mind under duress, and there was some exchanges at the time to say that that was the case, that they still didn't agree to it, but they were going to sign it, and then claimed after the fact for the $28,000. But like I said, $25,000 is the limit from the small claims court, so that was as much as they could claim. So whose responsibility is it? Nobody. So what Adjudicator Pink says is that this is really nobody's fault in a sense, because nobody could have predicted that the price of lumber was going to go up. But what he said was, this was what he called a contract of adhesion, which is, he means a standard form contract, which is basically which you see often in any number of situations. It's here's our standard contract. We use this contract in every one of our transactions. Take it or leave it. If you don't sign this contract, we're not negotiating. There's the contract. You either sign it or you don't, and that's it. So what the adjudicator says, and this is a legitimate concept within contract law, is a contract of adhesion like that, standard form contract, the principle of contra proferentum, a little Latin there, there's going to be some more Latin coming up later, applies. And so any ambiguity, any ambiguous term within the contract is to be interpreted against the drafter of the contract. So in this case, Nature Ridge was the drafter. They presented the contract to the Faulkners. There was some language in there about increases and unexpected things, but nothing that would predict something this dramatic as the price of lumber increasing as it did. And so that ambiguity was interpreted against Nature Ridge Homes. And then, well, okay, that's one part of it, but they consented to sign for the additional cost of $28,000. Well, that was done under duress, they claimed, and the adjudicator agreed with that. There was essentially no choice but to sign it, and the pressure was illegitimate under the circumstances. So they got their home. They got the $25,000 back. The adjudicator mentioned this, and he said it wasn't argued, but he said, the Nature Ridge wasn't that disappointed or wasn't that concerned in a sense, because if the Faulkners didn't take the home, they would just finish building it, and somebody, they could have negotiated a new price with somebody else and would have sold the home anyway. So anyway, so the adjudicator sided with the homeowners in that case. Nature Ridge is the one that's supposed to know the industry better, and so anyway, if anybody's in an issue, situation similar to that, trying to negotiate the price of lumber throughout the pandemic, or knows anybody that does, there's an interesting case on how those situations would be resolved. All right. Next situation, just to comment on, the Nova Scotia Court of Appeal has issued an annual report. This is the first time they've done this, really taking a cue from the Supreme Court of Canada. I mentioned this a couple of weeks ago, that the Supreme Court of Canada issued an annual report doing some statistics and a little bit of write-up, a message from the Chief Justice. Same thing here. Chief Justice Michael Wood from Nova Scotia Court of Appeal talking about issues of access to justice, technology. There's a digital task force of which he's a co-chair. Webcasting, the Court of Appeal did some webcasted some hearings last year, I think half a dozen or so. Some of them had big audiences in the hundreds, some a little smaller than that, but I think their intention is to keep doing so. They mentioned that they had an African Nova Scotian community engagement session in the Yarmouth area, and felt that that was a worthwhile endeavor. Mentioned the retirement of Justice Jill Hamilton, who was 21 years at the Court of Appeal. Actually, Justice Beveridge also retired from the court last week, so I think there's now, I think Justice Beveridge would have been one of the 7. There's 7 full-time justices and 3 what they call supernumerary, which is semi-retired judges sitting sometimes. So you can expect soon some appointments to the Court of Appeal in Nova Scotia, I would say. Mentioned outside activities of some of the justices, including Justice Cindy Bourgeois, who is the chair of the Nova Scotia Electoral Boundaries Commission. Actually, it was interesting, in the report, which just came out a couple of days ago, they did report that the commission, the Boundaries Commission that is, filed a report, and it went to Ottawa to Parliament, and that 3 members of Parliament have objected to it, and that so there's more work to be done in the course of this next month. The Boundaries Commission is going to react to these objections from the members of Parliament. Don't think they'll think much of those objections. I think they'll stick with their report as they have it written. Objections from members of Parliament under those circumstances are usually just for things like the names of the ridings, not for gerrymandering the boundaries, as they seem to be attempting to do. In 2022, there were 123 appeals filed, 76 civil claims, 50 criminal ones, and about 10% of the litigants were self-represented, gone there without lawyers. Very difficult thing to do at the Court of Appeal, but some people have attempted to do so. All right, so that is the Court of Appeal's annual report. I want to talk about these other 3 situations. So these are the big ones. First, I'm going to start with the Trump indictment. He's been indicated, as I saw he put on Truth Social. I saw through the media. I'm not on Truth Social. So there's 34 charges. This just so fascinated by. I've been reading some of the American coverage of this. Like, none of these things would ever happen in Canada. First of all, he gets indicted by an elected district attorney. A district attorney, District Attorney Bragg, interesting name for somebody indicting Donald Trump, elected in the district, Lower Manhattan district, as a Democrat. So that's much different in Canada. There's non-partisan prosecutorial system in Canada, whereas they're elected in the United States, which of course, to me, just inherently taints almost everything they do. So there was one situation. The other one, there's 34 charges on the indictment, but really there is one charge. Now, this isn't different than in Canada, because prosecutors here do this all the time as well. They'll list, half a dozen or a dozen charges, but really there might be 1 or 2 situations, alternate charges, and, piling things on. Like if you breach probation, you may have breached 3 terms of the probation with 1 act, but you'll get charged 3 different ways. In this case, there's 34 charges, but the claim is that former President Trump falsified business records. He paid his lawyer, Michael Cohen, who not incidentally, who went to jail over this situation. Michael Cohen invoiced former President Trump over these payments that he'd made to Stormy Daniels. Trump reimbursed Michael Cohen and called it in his accounting records, in his Trump business records, legal fees. Well, so that's a mischaracterization of that. Misdemeanor, not a big deal, would be a summary offense claim here if it was even prosecuted. Unusual to even have something like that prosecuted. What the district attorney in New York has tried to do, though, is connect that to Trump failing or filing a misleading campaign statement. So campaign finance, breach, which is a more serious offense, makes it a felony. The other thing it does is it overcomes a time limitation. So for less serious offenses, here in Canada, it would be a 1-year limitation on when you could be charged. I think it's the same down there, but certainly, I mean, this is from 2016, so it's way, way back. So it overcomes that time limitation issue and turns it into a felony, which could potentially draw jail time. I can't imagine that would be the case in this case. But it's a novel kind of a legal theory that you can connect this falsifying business records, a very minor charge, back to something more serious and call it a campaign financing, a misleading campaign financing attempt. So it's a very political situation, and this has been in all the headlines, the first time a former president of the United States has been charged with a criminal offense. Although actually reading some of the New York Times coverage of it, there's a mention that Ulysses S. Grant, but while he was president, not afterwards, was given a speeding ticket in Washington, a horse speeding ticket. So that's how long ago that was. He was going with his horse and carriage with a couple of buddies and speeding down the road in Washington, D.C. He was given a warning one day, and the next day he was arrested. And he was so gracious, I guess, that he actually drove the officer in his cart next to him and had a nice chat with them down to the station. And he had to post $20 as a bond or something. And if he didn't show up, President Grant didn't show up the next day, forfeited the $20. That's the only precedent, and that's really not a precedent in a sense. So it's a novel legal claim. I don't, Trump is going to be able to argue, well, that wasn't a campaign issue, that was a family issue. Although he has some trouble there too, because there's one quote about, well, if it happens, if we can delay this until after the election, the 2016 election, then we won't have to pay anything. So that comment, if accurate, if proven, would seem to indicate that he connected it to the election. Certainly, and he denies the affair with Stormy Daniels as well, or the encounter with Stormy Daniels. But even if she had just come out, whether it's true or not, if she had come out before the election and said this happened, of course it would have had an effect not only on Trump's family, but on his election prospects. And so there is some connection to the election financing, but certainly not a slam dunk of a legal case. And so if this is the first time a former president is going to be charged on a divisive, weak case, really it's an indirect attack on what the real issues are. And there are two other cases. So to me, this is completely inappropriate to be charging a former president for something like this. He has two other potential issues where he could face criminal charges. One is this situation out of Georgia where he called, and this is recorded, he called the lieutenant governor in Georgia asking you have to find me, was it 18,000 votes or some, in the teens of thousands of votes to get him over the hump and win the Georgia Electoral College. Well, whether that was a suggestion of, all right, go out and find them if they're there, or go out and do whatever you have to do to make them up and thus find them, I think there's an open question there as well. So I don't think that case is particularly strong. The real case they want to bring against former President Trump, and they may as well do so directly, is this January 6th stuff, that he incited the riot and caused all of those things on January 6th. But again, is that appropriate? I'm not sure. It's certainly not going to help with the healing process in the United States. So we'll be watching all that as it goes along. This case out of New York, though, I don't think is going to hurt Trump in his election prospects. And, if it backfires and he doesn't get convicted, this is going to really, really inflame things politically. So, a mistake on the part of the district attorney, but it's a mistake that's been made. So let's, all right, we'll move on. Mass Casualty Commission proceedings. I've been reading this section's, volume 7 of the reports, the last volume on process. And there's some questions, of course, people that have been following my coverage of the Mass Casualty Commission would know that I have many criticisms of the Mass Casualty Commission's procedure, but that's not what they're talking about. They're talking about 3 different things in here. Well, they had mentioned other things as well in their process, but they were very, very hard on the RCMP in terms of disclosure. This is interesting now, like during their unveiling of the report, they didn't really get into any of this, and I think that was part of the reason for the muted reaction to the report initially, but they came out, they were critical of the RCMP and their performance, but they were very critical of the RCMP, very pointedly critical of the RCMP and the Attorney General, the lawyers for the federal government, about disclosure issues. They said they issued a general subpoena in March of 2021 to just say, all right, give us everything that's relevant to this case. But then they had to issue further subpoenas. They had to issue directions for written, right? If you can't disclose documents, then we want to know about this subject area of the, the organization chart, training in different areas. So write us and give us a written description of those things if you don't already have a manual or something you can disclose. So there's a ton of back and forth, it sounds like, between the commission and the RCMP, and it was very slow. They said, quote, that the most significant delay was due to the pace and manner of disclosure by the RCMP and Attorney General of Canada. That was after they talked about COVID having some delays. And then they went on to describe how at the G20 Toronto in 2012, that inquiry faced the same kind of problems with the RCMP. And then the Missing and Murdered Indigenous Women and Girls inquiry of 2019 faced the same issues with the RCMP. They said that the disclosure that they did receive wasn't labeled or organized, and so they had to read the whole thing. They couldn't just figure out what was relevant by their titles or any other thing about the document. They had to read everything, and so that took up a lot of extra time. That there was late disclosure of officer notes, and sometimes it was after the officer had already testified. And then they talked about this issue, you'll remember, with Darren Campbell's notes, one of the lead officers in Nova Scotia, that there was these 4 pages that were discovered to have been excluded from the original disclosure, included later, but the Attorney General never said, hey, by the way, we're sending you this new version because there was 4 pages that we thought might have been privileged, but we've looked at it and now we determined that they are not privileged and we're including them. That wasn't explained. They just sent them the second document. And somebody discovered that there was 4 extra pages and tried to figure out why and eventually did. So the commission looks at this and says, well, what else have we not been told was held back for alleged privilege reasons or any other reason? So they went through many different problems. Really, in a way, this undermines a lot of the, well, I don't know how much it undermines because we don't know what was missing. But it certainly shows that the Mass Casualty Commission had a lot of frustrations with the RCMP and their disclosure. It says, despite the RCMP having established an issues management team ostensibly to manage its response to the inquiry, that they had all these problems. So big issues with the RCMP on disclosure. Really, I think, had a negative impact on how quickly things got going and how much analysis anybody was able to do of the information. Second thing, they were very critical of Patterson Law. Now, Patterson Law, based out of Truro and offices in Halifax and Glasgow, have represented most of the family participants in the inquiry. And they were also representing most of the same, if not more of this, most, if not all of the same individuals in a civil suit against the RCMP and against Lisa Banfield. So the Mass Casualty Commission saw this as a real issue because they said, well, Patterson Law is using the inquiry processes to, build up their civil claim. And that is where their focus is. The inquiry is supposed to be set up in the public interest, and that's, the only perspective we're supposed to have, and the lawyers for the participants are supposed to have in that process. And so what they not only commented on that, but now they've urged law societies throughout Canada to analyze whether they're a law firm or a lawyer representing a client in an inquiry and in a civil claim is a conflict of interest. So really going after Patterson Law in particular on this one, and be interesting to see if any of the law societies pick up on that. I mean, it seems very natural. I mean, the issue is, a client needs to be able to choose their lawyer as well, and you shouldn't have to choose a second lawyer. But the issue they say is, well, if you're going to use the inquiry process to advance your civil claim. On the other hand, the defendants are going to be affected because they're going to be reluctant to disclose and participate in an inquiry if they're worried, on the other hand, that they've got a civil claim, looming that they're going to have to defend. I don't know. I'd be very interested to see how the law societies treat this. It seems to me, all right, this is just reality, right? I mean, there's going to be a civil claim. They're going to try to use the process. Yes. That doesn't mean the commissioners can't. To me, that's an issue for the commissioners to manage. Like if you're asking inappropriate questions that seem designed for a civil claim, well, somebody can object to that, and the commissioners can, sustain an objection and then move on. So they don't need to design a whole new system for that. Anyway, that was really interesting. I mean, throughout the inquiry, there was a dynamic there of Patterson really pushing, the commissioners, the commission, the other parties to, disclose things, to allow more questioning, to allow cross-examination. And, other parties were doing it too. They were the most prominent among them. So I think their presence was quite valuable, and I don't see that as the issue that the inquiry people do. Of course, from the commissioner's perspective, they just is one less troublemaker, if in a sense, if they didn't have people that were representing people on a civil claim in the room asking all these difficult questions. All right, last one I mentioned, I thought it was interesting, was the commission goes out of their way on page 160 of the volume 7 to criticize Premier Tim Houston. All right, so remember the very first day, just as the commissioners, they were under the fire, there had been the review, and then the inquiry was finally called, and it was delayed, and all these questions. And so on the day of the inquiry opening, Premier Houston and Minister Sean Fraser had both issued statements saying, you should be meet with the families, you should be responsive to the needs and wishes of the community members and the families, and this doesn't seem to be going well. So the commission now criticizes Premier Houston, although they don't criticize Minister Fraser for the exact same message from the federal government. So that's peculiar. About trying to interfere with the commission's work, talking about meeting with the families, ignoring that there are other participants. This is what the commission says in the report, and all that stuff. So to me, that just shows a continuing misunderstanding of the concept of independence. I mean, they think they're independent. The commissioners thought they were independent, but they were in fact a creature of the federal and provincial cabinets, answer to the cabinets. They report to the cabinet and could have been ended at any point by the federal and provincial cabinets. So they were not independent in the way they seem to think. And then there was no contrition throughout the whole report. I haven't seen anything yet, unless if somebody has, please point it out to me, because there was nowhere in there where the commission says, actually, we might have got things wrong, or yeah, I guess, people, our critics may have been right on this point. Never. They never say that. So this is just another example of them pushing back needlessly, in my view, against Premier Houston. All right, final story, because we're getting up to half an hour here, is the Canadian Civil Liberties Association. By the way, just on the back to the inquiry for a second, I'm going to be on with Jordan Bonaparte and Paul Palango Sunday night talking about that, talking about some of these issues on Volume 7 in the process, but some other topics as well. And I'll continue to cover this over the next few weeks as I keep reading more of the report. All right, final issue. Canadian Civil Liberties Association is taking the federal government to court, or they have taken them to court in federal court over the challenge to the Emergencies Act, the invocation of the Emergencies Act during the trucker protest. All right, so I wonder, is this deja vu? What's going on here? Didn't we already have an inquiry over this? Yes, we did. The Public Order Emergency Commission, led by Justice Rouleau, heard all of these points and made a ruling on them in February, just a month and a half ago, to say that, yes, the government was authorized, they were justified in invoking the Emergencies Act, but also he went on to say, all right, this is the first time anybody's invoked the Emergencies Act, so I'm going to talk a little bit about what all that means, what the legal standard is, because there was some confusion about the legal standard, because there was reference in the Emergencies Act to the CSIS Act, the spy agencies legislation, and their definition of an emergency being a national attack, basically. Something that undermined the democracy of the country. So Justice Rouleau tried to give an interpretation, or his interpretation of how the act should be read, but that is not binding. It was an inquiry report. It wasn't a legal ruling in the sense that it would bind future courts. So it was still legitimate in the sense for the Liberties Association to take the federal government to court over this and claim, well, you haven't met the threshold. But it seems highly unlikely that the federal court is going to deviate very far, if at all, from Justice Rouleau's interpretation of the Emergencies Act. First of all, I mean, the biggest distinction, or the biggest potential distinction, I think, from what the Civil Liberties Association is asking and what Justice Rouleau ruled already, or spoke already, was this, does emergency need to mean like, the army's pouring across the border, or, we're being undermined by a spy network, or something of that, level of seriousness? No. He said it can be something like, this, where it's just overwhelming security forces and police forces. So I suspect that this federal court justice, Justice Richard Mosley, is going to come to the same conclusion, or similar conclusion, maybe word it differently, but it'll be then a binding one for future use of the Emergencies Act. So it's a useful exercise in that sense, that it'll establish at least that this is the legal standard for using the Emergencies Act. Now, the Canadian Constitutional Foundation lawyer did make a good point, I saw in the CTV News article covering it, that just because measures worked does not mean that they were justified. All right, yes, of course, draconian measures are often going to be effective. That doesn't mean they're appropriate. I mean, it still has to be within the confines of the Charter. I'd be very curious to read this decision when it comes out, to see what Justice Mosley says about that, and how charter rights of free citizens interact with the Emergencies Act, and how that's going to work for future considerations of whether to invoke the act. All right. Final just point on that is the federal government is now also saying, or trying to argue, that the issue is now moot since the emergency is over and the emergency declaration is over. Don't think the judge is going to, I don't know why they bothered to make that argument, but I don't think the justice is going to accept that. It's still worthwhile to provide guidance for future situations based on an actual scenario. So, all right, so that's that. He has reserved decision. It's going to take him a while to come up with a decision. Reserved decision without date. Sine die. SINEDIE. Little more Latin for you there. That's adjourn without date. So that's not unusual for a court process. Okay, so those were the interesting cases I thought this week. The lumber case, from lumber to Trump to the Mass Casualty Commission coming down hard on the RCMP and Patterson Law, and the Canadian Civil Liberties Association taking the federal government to court. So anyway, I hope everybody found that enlightening, interesting, or enjoyable in some way. If you, like I say, if you enjoyed that, please like, subscribe, and share. And otherwise, enjoy your Easter weekend, and we'll see you next time.